Good morning and welcome, both to those here in the hearing room in Edinburgh and those following proceedings on the YouTube feed. Can I extend a particular welcome to those, I can see at least one core participant who is attending in person in the hearing room. I would wish to acknowledge that engagement. Now, the Scottish Hospitals Inquiry has finished its hearing of evidence from witnesses and consideration of documents. As I have been reminded, we have heard, I think, 186 witnesses, and we have considered many documents over a period of hearings extending to, I think I'm right in saying, 29 weeks. Now, these hearings have been in a number of sessions, which we have designated Glasgow 1, Glasgow 2, Glasgow 3, and Glasgow 4. Glasgow 1 was in 2021 when we heard from some patients and family members who had very direct experience of particularly the Children's Hospital in Glasgow. Glasgow 2 hearing was in June of 2023. Glasgow 3 was a hearing over 12 weeks with a break of a week from August until November of 2024. And in 2025, we have had the 3 parts of the Glasgow 4 hearing in May, then in August, and then between September and October. So the inquiry has heard the evidence. What I have invited legal representatives to do during the 4 days of this week is to, in oral submission, draw my attention to what they consider to be the important aspects of that evidence and the important issues which that evidence gives rise to. It will allow legal representatives to respond to what has previously been provided to the inquiry by way of closing statements. Following the end of the 3rd part of Glasgow 4, I invited core participants to provide closing statements, and all core participants have done so in writing by way of their legal representatives. I've considered all these written statements, and I'm very grateful for them. They have been helpful. As I say, today is an opportunity, today and following days is an opportunity for legal representatives to draw attention to important aspects of their written statements and the written closing statements of other core participants. It also provides me with the opportunity to ask questions. Counsel to the inquiry, Mr. Connell today and Mr. McIntosh on Friday will also have the opportunity to make oral closing statements. With that by way of introduction, can I turn to Mr. Connell and invite him to address the inquiry?
Thank you, my lord. It's not quite the final curtain, but the final oral hearing has at last arrived. Quite a significant milestone, I might suggest. In the words of the song, it has been a long and winding road. Some might argue slightly unnecessarily long or unnecessarily winding. As this will be, in all probability, the last occasion in which I will address your lordship in a public session, I'm going to take the indulgence of offering a couple of thanks. And one is this: I'd like to express the thanks of counsel to the inquiry, to the much wider inquiry team, many of whom have been effectively invisible to the public because they don't participate in the public sessions directly. But without them, those of us who perform on this stage would simply have been unable to achieve what we have managed to achieve. So our thanks go to them. I would also like to extend my thanks to core participants for their cooperation during the inquiry, which has allowed us to move forward much more smoothly than might otherwise have been the case. My thanks even extend to NSS, who have borne with considerable good humour the occasional mild grumbles on our part when they picked us up on matters of fine detail in one statement or another. But thanks to all the CPs. Now, as my lord has said, my role today is to respond, as it were, where necessary, to the written closing submissions by the various core participants who have made them. And I'll endeavour to do so broadly in the order in which they are either scheduled or originally intended to speak in this final session. Many of these submissions are lengthy and detailed, and I've absolutely no intention of dealing with every point they make. Otherwise, no one else will get a chance to speak this week at all. But that is not intended in any way to decry the effort that has been put into these well presented and argued submissions. There is, as my lord is aware, a written response that has picked up a lot of the detailed points that were made by core participants, and that has been produced, I think, and circulated. And I don't
just to clarify that point, particularly with a view to people following our proceedings.
Yes.
I think, correct me if I'm wrong about this, this is a reference to a document prepared by counsel to the inquiry, picking up on errors, points of detail, which core participants, legal representatives have very helpfully picked up on, drawn to a counsel's attention. These have been addressed, and as it were, a response has been provided.
That is exactly correct, my lord.
Right.
The points picked up range from errors in discussion right through at the other extreme to incorrect footnote notation. And it was thought undesirable to take up time in today's final session by dealing with these matters orally. So that has been produced. Now, it's possible, just by the nature of things, that there may be minor areas where I duplicate what is said there, but hopefully these will be at a minimum. So that said, I turn then to the closing submissions by the core participants, and I start there to be the next speakers with that for NHS GGC. I may have a little more to say about this one than some of the others, perhaps for a variety of reasons, including what they describe as their unique position in this inquiry. and I'll try to refer to the paragraph numbers as I go. I think the first thing I should say about that submission is that it would be wrong to do anything other than recognise and welcome what I would suggest is a very significant change of approach, which appears in this written document. I think the first written document from NHS GGC which contains that change of approach. So that is the right thing to do. I welcome that change of approach. Now, I am aware that the next question that a number of parties will raise is, well, is it real? It's said to be a change of approach on a whole range of fronts. Is that a real change, or is this something merely evident on paper? And that will be a question which my Lord will have to address in due course. I am conscious that the publication of the NHS GGC response has drawn comment in the press and elsewhere. Perhaps oddly, that comment is almost entirely focused on their position on infection link. That's almost the only thing that most of the coverage mentions. And I suggest, with all due respect, that there are other areas, some of which I will pick up, but not all, where significant things are said by the board, which are worth looking at. For instance, their position on whistleblowing is important, just to pick one. There are significant statements accepting failures right through the process of the building, design and building of the new hospital, expressed in plain terms. All of these are, I would suggest, worthy of attention. I don't suppose I can leave it without noting that the word humility appears in this submission, I think almost for the first time. This is an interesting phrase in the context of an organisation which has been described by some as an organisation which always knows best or which wants to go its own way. But humility now seems to be said to be an appropriate label for its approach. The other thing, I suppose, it's difficult to leave without saying is this: it's just perhaps a little disappointing that this change of position did not come a lot earlier. Now, the other thing I need to say is this, that we are told there is a change. We were, I think, first told about this in the oral evidence by the current Chief Executive, Professor Gardner. I suggest we do not yet know how, why, or when. How was that change decided upon? Why was it decided upon? When was it decided upon? There are hints, but I don't think we really know that. And I suspect that many of the parties to the inquiry would find it helpful to understand that process if, as part of the process of being convinced by what is said to be a changed position. Well, Lord, if I can now turn to the terms of the closing submissions for the board themselves, and I'll simply pick up a number of paragraphs. If I start just by noting paragraph 1.3, which is perhaps one that I note particularly as one of counsel to the inquiry, that NHS GGC agrees with our assessment of the evidence other than as set out specifically in the submissions they have lodged. my Lord will recall, there was a very substantial assessment of the evidence contained in the submissions that we put in. Having noted that, I then turn to section 3, which is the position of NHS GGC. Now, I think it's fair that I should immediately welcome statements made, particularly in paragraph 3.1 and 3.3, where, for instance, in 3.1, NHS GGC say that its management of the issues investigated by the inquiry fell well below what patients, families, clinicians and staff should expect. 3.3 says similar things. So I very much welcome the approach taken there, that acknowledgement of points that have otherwise been contested, and I suggest contested by witnesses who either were or are employees of NHS GGC, but this is now the board position. In paragraph 3.2, perhaps in contrast, the general assertion is made that all their staff at all times did what they considered was best for patients in good faith and were committed to patient safety above all else. Now, for our part, we find that statement rather more difficult to accept. I'm not going to go back into the story of communications, but that's an area where there are issues about that commitment. There are, trying to think of another example, changing the direction of an IMT so that it focuses on exculpating the building. Is that consistent? Pushing the nothing to see here approach. Is that consistent? And it's not within our remit. Not everything said in the investigation into the complaints of A&E consultants suggested that patient safety was the main objective. So that paragraph, I suggest, is not correct. Now, if I just move to 3.4, the only point I want to make there, and this may turn out to be simply a misreading, in 3.4 there's discussion of the building project, and about 2/3 of the way down it said NHS GGC accepts there were failings at handover and commissioning for which it must accept some responsibility. Now, I just raised the question, and I'm afraid some of the points I make do amount to questions as to whether that should be read as meaning that NHS GGC do not accept any responsibility for anything prior to handover. It would seem a little odd if it was to be that, because there are other parts of the submission which seem to accept failings at an earlier stage, but that phraseology in 3.4 seems to point in a particular direction.
How do you I mean, this is not your language, it's the Health Board's language. How do you understand the word commissioning?
Well, I take that, my Lord, because it says handover and commissioning, to be a general rather than a technical phrase, to reflect the processes taken to move the building from one which was a shell to one which was working and ready for the occupation of patients. Yeah. I think that's the way I would have viewed the word handover and commissioning.
I think the expression used to describe that at least on some occasions, as operational commissioning. Is that an acceptable way of describing it?
That would be near to my understanding of this phrase, that the period after the board, as it were, gets its hands on the building for the first time, and then the process by which checks are made or not made, as we've heard in the evidence. Lord, if I then move to 3.6, now, I suggest that deals with two issues. One is NHS GGC, and I'll come back to that, and the other is NHS Assure, which of course is a new body born, as we understand it, largely out of the issues at the new Glasgow hospital. My position on that is quite simple. It's not difficult, in my submission, to see that the creation and indeed operation since its creation of NHS Assure is a significant step designed to assist with some of the issues that we have been considering. And we had detailed evidence on what they were doing, what they were hoping to do, all the various steps that they were taking. So in a sense, we have the vouching for that. The question, and I'm sorry to have another question again, that I have is this: why can this inquiry be assured that NHS GGC has developed and improved? It's not immediately clear from the material that I have seen why that should simply be accepted, but perhaps my understanding is flawed. Now, when I come to my next point, Lord, I'm going to take my Lord on a little tour.
Just before you do that, I mean, again, I appreciate this is not your document. What is being said here, and what is the relevance of NHS Assure, which, as I think you've said, was only established in 2021? Do you understand what's being said here?
Well, part of my difficulty is that when I listened to Professor Gardner, I got a little lost about journeys and unpacking and arriving at the destination and other such management type phrases, which were obviously intended to indicate something. This paragraph, I think, suggests that there has been a process of improvement which has come to, if not a conclusion, but is well advanced in picking up a lot of the failings which I've identified elsewhere in these submissions. I think the challenge may be that, in part because the change of approach by NHS GGC came when it did, it's not entirely obvious to me why one should just be assured now, immediately, that all is well in the board. However, one takes the current chief executive's statements on these matters. I think that the problem is the word assured. How are we to be assured, to take the start of that paragraph? Now, in fairness, they do say they continue to learn and so on and so forth. So I'm not suggesting they've set out a journey which is completed. They haven't finished unpacking yet. But that's the nearest I can come to an understanding of that paragraph. What I was going to go on to do, if I may, my Lord, is go on a little journey on a topic. My Lord may recall the evidence of previous Chief Executive, Ms. Grant, on what the approach of the board was, on what her approach was to the conclusion of the case note review that there was infection link in a significant number of cases. Her evidence on that point extended over a substantial number of pages of transcript, and counsel to the inquiry have suggested that it would at least be open to your lordship to conclude that the then chief executive and possibly other senior officers decided that they did not accept the case note review conclusion on infection link, but also decided that they would not say so, notwithstanding the apology that was issued and the other processes that were ongoing, that they would not say so because of the fact they were still in what I'll just call special measures, or the fact that it might upset parents and so on, and no doubt it would have done had the case note review come out and said there's infection link, and GGC come out and said, well, we entirely reject that.
Ms. Grant did not say that in terms.
No, she did not. I'm not sure we know, but the matter is discussed quite fully in our submissions, and it had occurred to us that we might hear from NHS GGC clearly what the position was at that time. Now, Professor Brown says he wasn't told anything about it, but we're looking at the position of the executive. So I thought might find that explanation in paragraph 3.9, where there's discussion of the position of NHS GGC evolving, but I don't. I just from my Lord's notes, I've looked at other paragraphs. If I can just jump ahead for a moment, if my Lord sees paragraph 4.4, it said NHS GGC has accepted and has acted upon both the conclusions and the recommendations of the CNR overview report. Their position on the CNR is set out in more detail in 1311 and 1312. Well, we know what they've done now. The question is what they did then. The other place I looked was 5.9. So if I just go there, all that is said is that it's not accepted that NHS GGC was any way disingenuous or dishonest as to its position on the CNR. This position is addressed more fully elsewhere. Well, that's a general claim, but nothing further is provided. There's reference to it, I think, briefly in paragraph 9.1, where there's discussion about cover-ups. So I thought, gleefully, I may say that I would find the answer in paragraph 13.11 and 13.12. Unfortunately, I don't. All that's said in 13.11 is a discussion of the CNR. There's a claim in the third line that NHS GGC hasn't changed its position. I'm not sure whether that's a statement of the technically correct in the sense that if the board was never told and thought it was accepted, and the executive did a different view, that's not a board view, that's an executive view, or not. But I don't find anywhere there any explanation to indicate why it was apparently that there was a different view of the CNR, which led to the view on the CNR, which, as we know, was ultimately expressed. And we've dealt with that very fully in our submissions, and in my respectful submission, we haven't had a reply.
Remind me, have we seen a board minute dealing with the question as to whether the, dealing with the CNR?
Not that's particularly helpful to us, no. I mean, we have the evidence of the chairman of the board,
Yes.
Professor Brown, that said, well, as far as I was concerned, everything was accepted.
He was quite clear about that.
And that at least was not what the then Chief Executive, Miss Grant, was saying. Because she was asked any number of times, did you accept the infection-linked conclusions? And gave a variety of answers. And we've dealt with that very fully, and it suggested, I mean, we have gone so far as to suggest that if a decision was taken that the infection link was not accepted, but nevertheless the apology was made, and patients and parents were told various things, that would be a very significant event. So I had hoped that we might get the answer to that, but it appears not. So I apologise for going slightly out of order in the way I'm going through these submissions.
Well, you started this by saying you were going on a journey. Now, what was the purpose of this journey?
Well, the purpose of this journey is essentially, and I'm not sure I'm very keen on adopting the journey analogy, but nevertheless, I'll take that.
Chose to do that.
Yes,
if it's the wrong analogy, fine. But
the purpose of the journey was to try to illustrate that a clear statement of what the position of the then Chief Executive and senior officers of the board was on the CNR at the time is not discussed in these submissions. And part of my reason for that, for raising it, is that a very significant potential criticism was made in submissions by counsel to the inquiry to the effect that if the position was that that was not accepted, then allowing the board to think it was, allowing, or at least the chairman to think it was, allowing patients to think the apology was all-encompassing and so on, could well have been misleading, to say the least. Now, Maud, if I can get off the journey and go back into the text, if I go now briefly to 4.3 in the submissions. I'm going to come back to 4.3 at a later stage very briefly, but I just noticed that paragraph, which contains the now much quoted acceptance by NHS GGC on the balance of probabilities that there's a causal connection between infections and the hospital, starts, and my respectful submission, perhaps slightly unfortunately, starts with there is no definite link between infections and the water system. Now, it may simply be that that is an expression about scientific absolute certainty, and one should read it as no more significant than that. But no doubt, if my understanding is incorrect, I can be told later on.
I have to confess, if it's not that, in other words, if it is not saying, which after all is what the CNR said, that one cannot be absolutely definite in a scientific sense. If it doesn't mean that, then I don't know what it does.
No, I suppose the position that we took was that in circumstances where the second part of that paragraph, the acceptance on balance of probabilities, was clearly going to be of major interest, I just wondered why the paragraph started by emphasizing the question of no definite link. But I can't take the point any further below. What I can do is go to the next paragraph, 4.4, and ask this question. That paragraph says, sorry, I'm just I'm in the wrong paragraph, 4.5. In 4.5, board accepts that previous criticisms of Dr. Inkster and the whistleblowers are neither helpful nor fair. Were neither helpful nor fair. Question: when was that decided? because that also, I would suggest, is a significant change of position. And again, we don't quite know how that was reached. Because, I mean, it's not necessarily unfair to say, well, who was it that decided that the very critical approach adopted to the whistleblowers almost throughout this inquiry should be so adopted? Presumably, it must have been the chief executive, Ms. Grant, but I don't know. Somebody must have decided that. And now it's accepted that this was wrong. In fact, unfair.
Well, it doesn't say it's wrong.
No.
It says it's neither helpful
well,
nor fair.
Well, it doesn't use the word wrong, but if the criticisms are not fair, then and I note the next sentence says,
and in the context of an inquiry, is the word helpful perhaps significant?
Well, it may be, my lord, because the inquiry can only proceed on the material placed before it, and if a party adopts an approach which it now accepts wasn't helpful, then that makes our task, your task, more
Does it
difficult.
not go a bit further? An inquiry is obliged to respond to the material that is put before it.
Well, indeed. And that's why I mentioned the change of approach, because a particular approach has been adopted. I suggest that must have been a deliberate approach. It must have been instructed by somebody. And now, at this stage, we're being told these criticisms were neither helpful nor fair, and they are withdrawn and indeed apologised for. And then there are other comments on whistleblowing. Well, can I just move to one or two issues that might be focused more on the construction side of the project? In paragraph 5.11, there are a number of statements there. A lack of appropriate in-house expertise and sufficiently rigorous scrutiny and so on. And then there's a mention of the organisation Capita. Now, Capita are not a core participant, but did give evidence. And it suggested there that Capita were appointed named supervisors within the NEC3 contract. That is correct. And it says, and we're responsible for checking and providing assurance to NHS GGC that the building was delivered in line with the agreed contract. Now, our position on that is that there was evidence from Mr. Redmond of Capita, and for Lord's notes, the bit I'm talking about is in our submissions at paragraph 1569. There was evidence from Mr. Redmond that they were not called upon to carry out the assurance role, their instructions being phrased as if called upon, and then a series of things. I don't, and the fault may be mine, I don't recollect any contradiction to that statement. No one produced anything calling upon them to do that role. So I question whether the statement in 511, if it intends to contradict that, is covered by the evidence. Well, if I can move on, 6.9 contains some very helpful comments that, for instance, that parties who have not migrated into a new hospital shouldn't have to migrate out of them, whatever Mr. Calderwood said. Shouldn't have been a need to decant a unit and so on. It's just notable, perhaps, that in 6.9, the board don't pick up any question of any contribution by anyone from NHS GGC in specifying what was required or operating in the project team or any of these issues. They make very fair points, but they don't identify any issues which are directly related to their teams.
Sorry, can I just take a moment here? As you say, it should not be the case that clinicians and patients moving from older hospitals should have lower quality facilities. That seems uncontroversial. The ones they left, which negatively impact on patient care. Right. So from the word however to the end of that paragraph seems entirely uncontroversial.
Well, indeed, and I welcome the acknowledgement.
Right. Do you know what the first two sentences mean? A design and build form of contract is a design process requiring the appropriate responsive resources at the required time to iteratively develop the design. Well, I suppose that might be so.
Well, that might be so. I mean, and then the next sentence talks about failure to have adequate resources.
Adequate resources available at key stages meant not everything that was requested could be provided.
Well, I'm not sure I follow that. I mean, I took the first sentence to be probably a pointer towards the fact that when matters were being designed, neither the project team nor anyone assisting them was in a position to pick up and develop some of the questions and queries which might otherwise have arisen over the specification of different areas. Now, here it's expressed as resources. I'm not sure it's ever been a question of, was there enough money in the pot? But I think that's probably what that is a hint to, and perhaps I'm simply pointing out that there's no real acknowledgement of any failings on the part of anyone in the board in these areas.
It's not really any detail.
No.
Right. Sorry, Mr. Cole.
If I can go to paragraph starting at 6.12, running into 6.13, 6.14, I needn't go through these, but my Lord will remember a number of the NHS GGC witnesses were reluctant to accept there was really any problem or any problem they were aware of or should have been in existence about resourcing. But one will find in 12, 13 and 14 of this section broad acceptance, as I understand it, by the board that things were not done as they should have been done in terms of resourcing and response to requests for resources. And I welcome that.
The paragraph offers an obvious example. I think it's an obvious example of the to illustrate the hospital opened too soon. Am I right in thinking that the multiplex position on the absence of HEPA filters in the filter casings, the explanation for that is that they were told to omit them, or is my recollection faulty?
That is an interesting section because, as I understand it, the multiplex position is that the specification produced by their ventilation designers simply provided for the casings. That's what they provided. However, it's also fair to note that when the context of the absent filters was discussed with them very urgently shortly after the hospital was handed over, no one seems to have taken a contractual point and declined to provide and supply the filters. There was some challenge about getting them very quickly, but it was done. So whatever their position may have been on the contract, they don't seem to have stood on that point on the day.
My point is a very minor one. It's just that I wonder if that's the most obvious example.
Well, I would suggest not, Maud. there are some very general acceptances of failures on the part of the board in these paragraphs. And my suggestion is that these have rather wider implications than simply the HEPA filters. I mean, one gets to the end of that section and it almost ends with a section, they did not resource or manage the project properly. You can't get much more general than that. They ought to have done. Well, moving on, I got a little puzzled, I have to say, about the phases that were set out in these submissions. We have phase 1, pre-2015, before handover, 2015 to 2025, and then phase 3, which appears on page 14 of the submissions, phase 3, 2025 onwards. I confess, having read the submissions, I'm not entirely clear why 2025 onwards is a phase at all. But I suppose it comes back to this question that I raised earlier. When did the board decide to change direction? And how do we know? And indeed, has anyone ever discussed why the previous direction was unsatisfactory? I haven't seen anything. But again, maybe I'm not looking in the right place. Just a general point there. Or can I touch on section 7, which is whistleblowing?
Right. I mean, just to follow this, the right. So it's what the inquiry is being offered in paragraph 6.7 are looking at 3 time periods, and I suppose contrasting in the first 2 of the time periods, commenting, I think broadly speaking, critically on GGC's performance and contrasting that with the future.
Yes.
Right.
But of course, we need to bear in mind that the apparent change of position of NHS GGC on a variety of issues, change of tone and everything else, only really first emerged in the oral evidence of Professor Gardner, which is very late on in this process. Well, others will want to say things about whistleblowers, which starts at 7.1. I only have a few comments. The inference from this general section is that, well, things were very difficult and unprecedented and challenging and so on and so forth. And that is somehow offered as an explanation. And my submission is this, that being under pressure in difficult circumstances might be precisely when it is important to treat whistleblowers properly. Because when difficulties arise, that's when people are likely to be taking these steps. And also, just to say, and I'll come back to this, that if the approach until very recently by NHS GGC to the whistleblowers is not acceptable, it's not clear to me why those who didn't treat them acceptably cannot be properly criticised. Now, the answer to that seems to be near the end of 7.1, that nobody should be criticised, and they are all experts in their fields dealing with serious and unprecedented situations. Well, I've dealt with the serious and unprecedented situations, and I suggest that expertise is not really the issue here at all. If people haven't behaved properly as they ought to have done, surely it is right that they should be criticised. The other slightly surprising feature, given what the inquiry now knows about whistleblowing as an issue in public service, is that at 7.4, near the foot of page 15, it seems to be part of the excuse for the board's behaviour that whistleblowing was in its infancy within NHS GGC. Now, that just struck me as a slightly odd excuse to proffer. Issues over the treatment of whistleblowers have been around for some time.
I was a little puzzled by that, because I think there's a GGC policy document or framework document dated in 2013.
Well, indeed, there have been other iterations of these things, but it doesn't.
It's not as if it's, well, anyway.
It's not a new topic, and all I'm suggesting is that precisely when you get, the approaches that were adopted to Doctors Peters and Inkster in 2015 and Dr. Reddy in 2017, and they were raising questions, they weren't getting these questions dealt with. That's when you get the issues arising. So to say, oh, well, the first NHS Scotland whistleblowing standards were only introduced in April 2021 doesn't really answer the question. Beyond that, I'll leave whistleblowing.
Well,
others will talk about that, no doubt. Though I do note, and my Lord will have read in paragraph 8.1, page 16, that points raised by Sir Robert Francis in his report to the inquiry, both as principle and also with application to NHS GGC, are accepted. So there's no challenge there. The board turns again to no deliberate concealment of information, and I've largely dealt with that, and I've dealt with the example of the approach to the CNR earlier, so I won't repeat that. I'll move to a different topic. Paragraph 10, relationship with RHI. Now, it says in paragraph 10.1, relationships between NHS, GGC, IPCT and RHI became challenging. Question, why? What was done or not done that should have been done? We don't know. And that is an area where there's been a lot of work to try to make progress, but unless we have acceptance and identification of things that were not done properly, it may be more difficult to be confident in the future, given the now infamous S-bar that Professor Gardner sent without comment in the not that recent past.
well, bear in mind we have a broader audience, some of whom are very well informed, some of whom will be less well informed. Now that's a reference to the S-bar dated, I think, in November 2024, in the name of the infection prevention
control team,
which
made a series of criticisms of various people, including experts instructed by this inquiry, and suggested they were sensationalizing points and so on and so forth. And that was sent by the chief executive to, if I think I'm right saying, the Scottish government, or I don't know.
Miss Lamb?
Yes, Miss Lamb of the Scottish government. And it was sent without any comment, although in oral evidence, Professor Gardner said, oh, well, she didn't think the tone or content was appropriate, and clearly had forgotten to mention that when she sent that on. But I simply make the point that unless there's some acknowledgement of what was done incorrectly, it's perhaps more difficult to be as confident as we would like to be that this relationship will, in fact, move forward.
Well, I was going to ask you, what is the point you make? The infection prevention and control team express their views in this document.
The chief executive says that
last
was
November.
inappropriate.
Chief executive says it was an inappropriate way of expressing things. Now, what do you take from
Well, from time to time, we've been dealing with people who are no longer in post. We're not dealing with that here. You have an existing team. A number of the senior people involved in infection prevention and control are still in post at NHS GGC and express these unguarded, perhaps I might be polite, views in that S-bar. So you have a chief executive who said that wasn't appropriate, either in tone or content. So you then have quite a challenging situation. Now, I'm not suggesting that our high and the board are not going to make efforts to deal with this, but unless one openly acknowledges what was wrong, one might find it more difficult to actually get to the final positive result in that relationship. And this submission simply says, well, relations became challenging.
Well, right. But in fairness to Professor Garner, she recognizes that should not have been said.
Yes.
And she also gave a fair bit of evidence of the work that she hopes will be done to ensure that people get on better.
Yes. Yes, she does. I don't dispute that. Lord, only a few more points about the board's position, hopefully. Paragraph 11 is headed, "The hospital is safe." All I say here is two things. First of all, I acknowledge that the position adopted by counsel to the inquiry on the use of the term safety has developed as the inquiry has progressed. I need say no more about that. It's dealt with very fully. But we've made a number of recommendations, propose suggestions for recommendations, and I'll just instance for my Lord's notes, those in paragraphs 1888 and 1889 of our closing submissions, which focus on what should be in the full business case, filling of water and so on and so forth, and no one has challenged these. So we acknowledge that the position has moved on.
Right. So you're referring me to the Glasgow 4 closing statement and paragraphs 188 and 189.
188, 1888, 1888, and 189.
Sorry, 1888.
Correct.
And 1889.
Correct.
Thank you.
Let me go to another paragraph, changing governance. Paragraph 12.2. Now, in and of itself, it's an interesting paragraph. Witnesses thought responsibility lay elsewhere, no one took responsibility and so on. Pretty damning criticism. But one of the notable things about the board's position is that all of the failures that they accept, all of the things that were not done that should have been done, or not done properly, or done inappropriately, or no instance of bad behavior appears to have been done by any individual at all. No one is criticized. It's all just, well, people were doing their best in good faith. In my respectful submission, that is close to being an untenable position. These submissions we're looking at the moment are replete with apologies for things that weren't done properly or not done at all. These things were all the responsibility of individuals. It rather reminds me, my Lord, of the almost comical exchanges early on in the inquiry where people were said, well, who told you this incorrect information about validation? And the answer came, the project team. Well, yes, but it must have been an individual who told you that information which was incorrect. And people were very reluctant to identify individuals. And just as a general comment on these submissions, it's our position that adopting a line under which no one is responsible for anything is not a tenable approach, given what we're being told.
Wonder if I can be more specific. Could we look at, on this issue of attribution of personal responsibility, could we look at paragraph 3.7 of the GGC closing statement?
3.7 more.
3.7.
Yes.
The full paragraph is QEUH RHC is a critically important hospital in Scotland and in the United Kingdom. It's essential that patients, families, and the public can have full confidence in it. There is considerable public interest in the report and recommendations of this inquiry. Public perceptions of QEUH RHC has undoubtedly been negatively influenced by the incidents that have been investigated by the inquiry. Now, it's the last two sentences that I'm particularly interested in your comment on. It is critical that the public can see through the work of the inquiry that people have been held to account. Where criticism is due, it is right that it be made robustly. Now, what's your comment on that?
Well, I have two comments. Firstly, that insofar as the phrase hold to account was examined during oral evidence in the inquiry, it was difficult to ascertain any real content to it. It seemed to be somebody might be spoken to, but that was about the sum and substance of it. So the phrase in itself may be misleading. The public might think that holding to account means that we're appropriate. I stress we're appropriate. There may be consequences if there is a failure, a significant failure, something done inappropriately. But so I don't place great credence in the phrase hold to account, but even if I leave that aside, the implication of these sentences is that it ought to be possible to identify and criticize those who contributed to failures. And the general impression I have from the remainder of the submission is that, at least wearing the NHS GGC hat, there is a reluctance to do that because everybody was behaving in good faith.
Well,
I'm not even sure good faith is the right phrase.
Well, may come to your reluctance point, but if we just look at these two sentences, it's critical that the public can see through the work of the inquiry that people have been held to account. Where criticism is due, it is right that it be made robustly. No. Do you agree with that?
Yes.
Right.
Yes, I do. And the point is that if you say, let me take an example. If you say the project team didn't do something very well, that doesn't really tell the public anything very much, because they say, oh, who are they? Was it one person or more people? Was it a committee decision? What was it? So that I would agree that the public ought to see that if there is failure, if things have not been done, that people, and that by that I assume is meant individual people, not a collective responsibility, have been held to account. Now, it may be that the board says, well, we're taking the all the blame on our shoulders. We're the collective, and you can blame us collectively. And that, I suspect, is the broad line that appears in these submissions. But I don't disagree with the proposition that people should be held to account.
Can I take you to paragraph 7.1?
Lord.
You, I think, have already looked at this.
Yes.
The taking up the paragraph beginning, it is submitted that personal or professional criticism should not be made of any of these individuals for how they reacted to the extreme pressure they were under. Now, these individuals are named,
Yes.
in 7.1. Now, do you see any tension between what is said in that sentence and what we've looked at in paragraph 3.7?
Well, I do, because if there is, I mean, particularly against a background where there is now a general acceptance that the treatment of the whistleblowers was unfair. If there is appropriate criticism of someone who participated in that process, then in my submission, there's nothing wrong with challenging them over that. And the point, I think the point that I was making about that paragraph is the fact that there were tensions, far from being an excuse, should not be treated as one at all. And secondly, it's nothing to do with the expertise of these individuals, because we're talking about treatment of whistleblowers. It's not whether they have expertise in some topic. So I do see a tension, but I return to my general theme that the line taken in these submissions seems to be to say nobody can be blamed for anything, or ought to be blamed for anything. Yes, people should be held to account, but actually when we pick them all up, we say, don't do it. And if one even just reads the start of the next paragraph 7.2 more, just to go to where Lord was, NHS GGC's treatment of the whistleblowers fell far below the standard expected. They were not adequately supported. They were not treated as they ought to have been. If they were not treated as they ought to have been, that must have been by somebody. But I think otherwise I'm likely to reiterate things I've said earlier on. A little peculiarity, Lord, if I can just identify it. 12.3, page 20. This is under the general section about governance. The issue is the issue of the board basically being ill-equipped to handle a process. 12.3, the issue was particularly acute when it came to receiving advice on design. There was little expertise within the board. Well, that might suggest go get some. The board was accepting of what it was told during the design and construction phase. It was reliant on the technical team. Now, those who have not watched the entirety of this inquiry will be aware that a debate arose about the use of the phrase the technical team, because there was at one point what was described as a shadow team of sub-consultants covering a variety of areas of expertise, including ventilation, and they were as a matter of deliberate choice, stood down early in 2010, if I'm remembering correctly. So
well, the contract was signed on the 18th of December 2009.
Nine.
And the Curry and Brown, who prior to that date had managed a team of sub-consultants, where their duties were significantly limited from about, is it January, February, March?
January, February in 2010.
Of 2010.
Yes. I think that the decision was communicated through the appropriate chain in and around that time. So during the design and construction phase, or at least most of it, so after early 2010, the technical team, as I think is suggested by other submissions that you have, my lord, basically, as previously understood, that team did not exist.
This is really a question for others, but there's maybe just a little ambiguity as to what is meant by the board. What do you understand? I mean, is it the board as represented by the project team, or is it the members of the health board?
Well, I think it's used possibly in more than one sense, because it starts by saying, this paragraph starts by saying there was little expertise within the board to cope with a project of this magnitude. Now that could apply to the board collectively, for reasons we've discussed, but also to the project team.
Well, wait a minute. When you use the word the board collectively, are you meaning the 40,000 employees of Greater Glasgow Health Board?
No, I'm meaning that the board in the sense of the corporate group which runs the NHS GGC, the statutory board, as it were.
Yes, I mean the people on the
board,
health board.
on the health
Right.
board. Yes. So little expertise to cope with a project of this magnitude could apply to the health board, the people on the health board, for reasons we've heard about. But it could also apply to those in the project team, because as my lord will have heard, many witnesses talked about, oh, this was a matter for the board, this would be approved by the board, it had to go, somebody in the board approved it, when they actually meant a representative, usually of the project team. And then the board was accepting of what it was told during the design and construction phase. Mainly that must be the project team, I think, because the statutory board wasn't told very much. I'm not sure I can sub-analyse that too much.
It's not really a matter for you, but the board was poorly advised, but lacked the expertise to challenge that advice, and the board is now in an entirely different place. Does that help or not?
Well, I still think it relates to a number of different uses of the board in evidence. It just struck me as slightly odd that we started this conversation by saying the board was reliant on the technical team, when we've had endless discussions about how the originally named technical team, i.e. the sub-consultants appointed by Curry and Brown, were in the main not in play after early 2010. Now, just looking briefly on the same page, 12.5, 12.6. Two things just so we're clear. 12.5 talks about being in line with the NHS blueprint for good governance. And my lord will recall that that was actually co-authored by Professor Brown, who of course was in the chair
Sorry, my fault entirely. Oh, yes, we're now on 12.5.
12.5,
Yeah.
yes. That blueprint was, I think, co-authored by Professor Brown, who was actually in the chair during at least some of the difficulties that we have discussed in this inquiry. So how valuable it is to say, to rely on that as part of the explanation for change, I'm not entirely sure. But more significantly, that these issues, all the blueprint and so on and so forth, all predate two things. First of all, Professor Gardner's witness statement to this inquiry, which was 25th of September 2025, in which no indication of a change of position was recorded. And secondly, then her oral evidence on the 9th of October 2025, which did indicate change.
Right.
Now,
I think you're moving between 2 points here.
I am.
Mr. Connell. First of all, before we let's start with the paragraph. The board and its standing committees have clearly defined and documented roles and responsibilities in line with the NHS Scotland blueprint for good governance. NHS GDC has an integrated approach to governance across clinical areas, performance management, staff. Now, the reference to the blueprint is a document which I think is in 2 editions, or rather the original edition has been revised. The author happens to be, although it's a document directed more, not simply at Greater Glasgow Health Board, happens to have been authored by Professor Brown, who has a particular expertise in this area. Now, can you remember the date of the original document? I think it may be 2017, but I may be wrong. If you can't,
I can't just immediately recollect.
Right.
I think I was making no more a point about that than these statements are no doubt correct, but where do they take us in being assured that the position of the board, which was heading in a particular direction until Professor Gardner spoke, has changed?
Right. Now that's the second point that I think you were making.
Yeah. And the first point is
specific to what one sees on one hand, or at least I think this is what you're saying to me, in Professor Gardner's witness statement, dating from August of last year.
September, 25th September.
25th of September of 2025. Well,
25th September was a witness statement which showed no indication of a change of position on anything. It contained some very general material. Most of the material that we'd be discussing actually emerged for the first time in her oral evidence on the 9th of October. My points are only twofold. Firstly, I question what value reliance on the blueprint has, since it was around for some time during the difficulties and the acknowledged failings that we've been discussing. And secondly, and perhaps more significantly, this paragraph, or these paragraphs, appear to be designed to support the proposition of change, but all of these things were in place well before Professor Gardner came here and told us of the bright new world that she was promising. And it rather looks as if they're trying to say, oh, well, if you go back, you can find X, Y, and Z to support that. But if it was there, it didn't seem to have had any impact.
Right. Now, and one can check this proposition. Professor Gardner provided a witness statement, which, as I recollect, she will have authored.
Yes.
I mean, is that right?
Well, one assumes so.
I mean, as opposed to something the inquiry produced.
Correct.
Now, you say the date of that was, did you say 23rd September?
My note says 25th September.
25th September. Now, Professor Gardner gave evidence on the 9th of October.
Correct.
So you are pointing to the possibility of what?
Well, if I go back, I mean, there was originally a question as to whether Professor Gardner was going to give evidence at all. That was then arranged. A witness statement was requested and produced. That witness statement, I forget all of the contents, but it contained various material, but nothing indicating any significant change of position on anything by the board. So whether one wants to describe it as anodyne, but certainly not critical. And then on the 9th of October, we got, for the first time, material about changing of position. So the question is, when did that change happen? On the face of it, if the intent was to help the inquiry, one would have expected, if there was a change, to see it mentioned in the witness statement, because broadly speaking, subject to questions, the witness statements might be expected to cover the things the witness wants to say. So is the change something which happened between the 25th of September and the 9th of October? It doesn't seem to be something that rises earlier. But and if I can, I'll leave that point, Lord. Few more. 13.8, I simply note this, given that it's controversial in some other submissions. I'm assuming it's quoted for a reason. 13.8 says Dr. Agrawal, who my Lord will remember was one of the HAD experts, but Dr. Agrawal accepted that conformity with SHTM 0301, i.e. the Scottish Guidance on Hospital Ventilation, can reduce airborne transmission in line with the inquiry panel. I simply note that that's an acceptance that appears in this submission, presumably advisedly, and it's helpful because it accords with the line that counsel to the inquiry take. However, when we come to 13.9, just immediately following that, which deals with the instruction of these experts by NHS GGC, well, we'll see the second sentence, the purpose of the HAD report is to assist the inquiry. Well, one could get into endless argument about that, but I'll not do so. And then it says, and provide detail on the wider management of infection risk. Now, what I suggest is that if my Lord looks in due course at the letters of instruction sent by NHS GGC to these experts, suggesting that details of wider management of infection risk was the topic on which they were to assist is not correct. In fact, they were given very little information about wider management of infection risk.
So your point is that the letter of instruction doesn't mention management of infection risk.
Doesn't seem to be the aim of the report at all.
Well, does it mention it?
Not that I can recall. But the point, just while I have it in my head, I promised to return to 4.3. And this may be important. 4.3 was the paragraph in which the board accepted on the balance of probabilities as a causal connection between infections and hospital environment. The question is, over what period is that accepted?
Well, there seems to be a disconnect between paragraph 4.2 and paragraph 4.3.
Yes. I mean, perhaps wrongly, I had assumed on first reading that the acceptance of infection link covered the period from, let's say, 2016 through until 2019, perhaps 2020, which appears to be what 4.2 says. But there are indications that 2018 is the end date to which the concession applies.
Is there any explanation why 2018
No.
appears in paragraph 4.3?
No, and it may simply be that I'm not reading these paragraphs correctly. But if it was the case that the board was restricting its concession to a period between 2016 and 2018, then I suspect my lord would need to know why that was and on what basis.
Yes, it's obviously an important paragraph.
Because it specifically says just so those watching are aware what this says in paragraph 4.3. It says NHS GGC accepts that it is more likely than not that a material proportion of the additional environmentally relevant infections in the paediatric hemato-oncology population between 2016 and 2018 had a connection to the state of the hospital water system. If that is the case, then I suspect it would be helpful to know the evidential basis for that potentially important restriction. Lord, 1311 makes a statement. The case note review did not consider other infection mitigations. We know that the case note review team had the entire patient journey, cleaning records, water and environment testing. I wonder whether that is a fair statement.
Well, just, sorry, which paragraph we're looking at?
13.11. It's just a question of whether it's fair to criticise the CNR for not considering other infection mitigations, given the whole of the material that that body had.
The CNR did a number of things. But what we're talking about at the moment is the consideration of the 86 pediatric cases. And the CNR was specifically tasked with 4 questions, 3 of which essentially, the first 3 essentially were whether there was, they could identify a link between the physical environment and the particular group of cases that had been identified for them. Now, what does infection mitigation have to do with that?
Well, I'm not sure, except it sounds like a criticism.
Or it clearly sounds like a criticism.
Criticism.
Can you give it any content or meaning?
Well, given what we were told about the steps that the CNR body took to find out about, if you like, the patient journey and everything relating to it and all the information that they had, I don't know what it's referring to, if it is a criticism.
And, well,
So it's simply because we're now in a situation where the board broadly accepts what the CNR broadly accepted, which probably, which is an infection link. So I'm not quite sure what the point being made here is. And just to finish that section, in the immediately next paragraph, there's a statement: if the instruction of the HAD authors to comment on the CNRs caused patients or families any upset, then there's a matter of extreme regret. That was not the intention. And I suppose my comment there is that given the apology that patients received after the CNR report was issued, indicating probable and possible links to the environment, it's perhaps disappointing that we don't have any acknowledgement here that any decision to challenge, to take a different view, was not communicated. In fact, I don't think was ever communicated to patients and parents until they found it mentioned in papers in this inquiry. Well, Lord, the next section deals with communications. That's a very well-trodden path, and I don't particularly want to re-walk it. This is another attempt, I suggest, by NHS GGC to set a test and then say the test is not met. It's linked to the previous statement, there was no cover-up. Well, cover-up suggests an organised and definite attempt to hide things, perhaps by an organisation. But that's not a phrase that I don't think Council of Inquiry have used, but Council of Inquiry have suggested that at various points statements were made which were not accurate and known to be not accurate. And I would suggest this, well, to try and get closer to the heart of it. In paragraph 14.3, in the middle of that paragraph, the board says that its communication style was at times defensive. Defensive means defensive of its position, defensive, and this approach was unhelpful. That's not much of a jump from that to a more popular phrase, which is spin, designed to put the board in the best light in the circumstances. And it's a matter of disappointment that that's not now accepted. I don't want to go back over matters that have been discussed endlessly previously, but the Lord will remember what was being done in Ward 2A as an opportunity for an upgrade. Now that's nothing more, in my respectful submission, than a phrase deliberately selected for image reasons. This is not saying that this has had to be ripped apart because it wasn't built properly for whatever reason. This is, oh well, we're taking the opportunity to upgrade the ventilation. And that, quite before you get to the question of whether anyone has been misled about the position on the CNR or the change of position on the CNR, or indeed the new position on the CNR, all of which have changed. So I'm coming to my conclusion on the board. That might be sensible for us to finish that, if I may, before we
Yes, there is a sort of legitimate expectation of coffee.
Indeed so. And I wouldn't want to disappoint anyone's legitimate expectations, lest I get detailed submissions from someone perhaps on the government side about what the definition of legitimate expectation is. But I'm close to finishing what I want to say about GGC, and I might just do that briefly, if I may, my lord. If I go to paragraph 15.2 under the heading of looking forward, what what I say is this, that lots of the participants in this inquiry are going to be looking for real concrete evidence that things have changed. And they will be reluctant, I suspect, to accept that any paper produced by Professor Gardner, however well-intentioned, amounts to concrete evidence that anything will actually change or has actually changed. Now, I've dealt with the fact that we don't have much material to show where this change came from, what the debate was about it, or anything else. But part of the concern is not eased, I have to say, my lord, by the fact that the board has recently written, as my lord is certainly aware, to Dr. Peters, Dr. Inkster, and
So you said the board has written to?
Yes.
Um,
Well, I take it these are letters instructed.
well, these you're referring to three
Letters from Professor Gardner.
signed by Professor Gardner.
Yes, yes. Signed by her as chief executive of the board. So Professor Gardner has written to Dr. Peters, Dr. Redding, and Dr. Inkster just very, very recently, 13th January, I think, in all cases, suggesting a meeting. Now, I think it's probably for others than me to comment in any detail on these letters, but my first reaction to them was that they read a little like the kind of letter that one's human resources department might have drafted when somebody needs to be brought in for a little chat with the boss. Well, and they can bring a friend if they want.
With respect, Mr. Connell, am I going to be assisted by your impression of a letter which I think I'll be given an opportunity to read?
The main point, my lord, is there are some things that don't appear in this letter. The most important one is the word apology. There's an offer of a meeting to discuss various things, but given where we are now, on the 13th of January, to write to these participants whose treatment is now accepted to have been inappropriate, without even mentioning an apology or acknowledgement of failure, or even an offer to listen to them rather than enter a wider discussion, may not be a helpful indication of where we're going. Perhaps my understanding of these letters is incorrect, but I suspect those acting for the recipients will want to address you on them in any event.
Well, I don't recollect Professor Gardner using the word apology in her evidence.
I think she probably apologised, but if I remember rightly, Lord, I think she apologised in her evidence, but said it couldn't be a board apology because the apology hadn't been approved by the board as a collective. But that was purely my recollection.
I think she said she was sorry.
Well,
I'm sorry that individuals did not feel listened to by the organization or were treated in a way that allowed them to feel empowered to be able to be harnessed into a solution and were not afforded that opportunity.
Well, I may be wrong in paraphrasing that as an attempt to make an apology by somebody who is accustomed to using management speak. The word sorry is at least an indication that that was the intention.
Right. So I'd be wrong to have, when listening to Professor Gardner, understood her as someone who only came into post in February of 2025 as being unable to apologize. I mean, she said in terms that she didn't feel able to apologize on behalf of the board, and one can understand that. So I would be wrong to interpret that as just an expression of regret that these things happened.
I think it can be interpreted in a variety of ways,
Okay.
but it can equally be interpreted as a statement by somebody who hasn't gone through the processes that she may think are necessary before she, as a spokesperson, can give a formal apology. And maybe we find the formal apology in the submissions that we've been looking at. But certainly letters suggesting a meeting don't mention an apology. They're also, oddly enough, all these three letters, bearing in mind that Dr. Peters is still in employment, Dr. Redding has retired, and Dr. Inkster is now employed by somebody else. They're all written in exactly the same terms, which is slightly odd. Anyway, I'll leave that for others to deal with. I've really nothing much more to say. There's a recommendation from NHS GGC, which I simply note in paragraph 16.2. 16.5 talks about.
Now, help me with this.
Yeah.
My recollection is that there was reference to what I understood to be a reporting template, which
Yes.
had been adopted by GDC recently. And my understanding is that that recommendation is for a more general adoption of the template. Now, my recollection, which may be wrong, was that I asked Professor Gardner if we could get more detail about that. Now, has that
I don't believe we've
arrived to your knowledge?
I don't think so, but
Right.
my understanding may be faulty on that.
No doubt it will be provided.
Yeah, but my lord is right. The recommendation is essentially that the board has produced a new form of reporting on various things and suggested that all boards should do that.
Yeah.
And I have nothing but myself to add which is of any value. 16.5 is a recommendation for facilitated discussion and mediation during whistleblowing. And the only comment I make on that is that I worry a little about whether this is driving back to the point that the whistleblowers objected to, which was focusing on personal relationship building rather than what is the substantive point we're trying to make and what are you doing about it. And really, I finish, well, just by saying this. I've said that many people involved in the inquiry will want to be convinced that change has happened. One of the ways of assisting the understanding of what is happening might be to explain to us who decided on the change, what discussion took place, debate perhaps, and how it was all done, and whether the whole board participated in that. And that might assist in public confidence. At the very least, there has been a full discussion on the matter, looked at all the issues, and this is the conclusion. And beyond that, I have nothing further to add on NHS GGC.
Right, but you propose to make submissions in relation to other closing statements.
I do, my lord. I have a little bit to say about a couple of the construction participants, if I can put it that way. I have much less to say for a variety of reasons, not least of which is that, about some of the others, because in some cases I take the view that you might be best to read the submissions undistracted by anything I might add to them. So I have a little bit to say about Curry and Brown and TUV and much less to say about anyone else.
Well, we have in the past taken a coffee break about this time. Can I ask people to be back for 12:05?
Please stand.
Mr. Connell.
Lord, I'm going to leave NHS GGC now and turn to some of those involved in the construction process and start by dealing with Curry and Brown and TUV Sud, or for most of our purposes, Wallace Whittle and ZBP. The first thing to say is that each of these participants advance arguments in their closing statements which are not in line with those made by us, Counsel to the Inquiry. That's not necessarily unexpected, but we don't propose to depart from our position as set out in our submissions. The other point to make is that these parties paint conflicting pictures about ventilation design. I'm paraphrasing slightly, but at one end, one has an argument that ventilation design is solely down to ZBP, the specialist designers. It's their job, they have to design it, they have to get it right. And at the other extreme, a view that the board, NHS GGC, had to specify every detail, and any detail not so specified would simply not be delivered. So you have two very different views of how the ventilation design of a project like this should proceed. Our position is that while we acknowledge, and we cover this in our submissions, that a clinical output specification should be as helpful as possible, we suggest that an approach nearer to that proposed by the lead consultant and architect, Emma White, should be adopted. In other words, recognizing that a clinical output specification is likely to be a variable content document depending on who prepared it, what their expertise is, and so on. And it is then for the specialist designer, using their skill and expertise and referring to guidance, to design what is required.
Just help me with this. You've introduced the notion of conflicting pictures in relation to ventilation design. Is that specific to the this contract, or are you making a more general statement?
It can only be specific to this contract,
Right.
because the submissions that parties make relate to this particular contract.
Right. Now, I have to be conscious that it's no part of my function to interpret the contract, but you're providing me with your understanding of the contract in order to give me a context
and the way in which
to consider what else you have to say.
Yes, the way in which I suggest the contract should have operated. And I do suggest that the approach that we adopt broadly accords with evidence given by Mr. Pardee of ZBP. And I just give you examples of that from our submissions at paras 437 and 1556.
Right. Could you give me these paragraphs again?
437, 430.
Oh,
Sorry.
37.
No.
My fault entirely.
437, 437.
437.
And 1556.
1556 in the G-Force
Submissions.
submission.
Yes. And just to avoid going into it, my Lord will be aware that the submissions made by Counsel to Inquiry maintain the view that providing air changes in accordance with the guidance in SHTM 0301 does have a value which includes, I've used the word safety, dilution for safety purposes, because that crops up from time to time and I'd have to repeat it a
Right.
lot.
Just give me that again. Providing the air change rate according
to SHTM 0301 does have a value which includes safety.
I mean, use the word have a value. Would objective be?
Yes, I'm content.
Well, I mean, that's a
yes,
sentence.
yes,
Okay.
yes. Now, the other thing I tried to do, my Lord, was to see whether I could provide a helpful analogy, because one of the issues that keeps cropping up is what function signing off drawings and documents is. And I confess, having made this effort, I'm not actually sure that making it has proved worthwhile, because ultimately there are contract provisions in this contract which say what they say. The nearest I came to one, and I will offer it only for what little assistance it may have, is that imagine a knowledgeable client who wants a house built. He's had several houses built. He knows a bit about it. He knows, and I'm using he, I should say he or she knows where he wants the rooms, that he wants doors that open onto the garden, so on and so forth. He instructs a builder. The builder designs his house, but wants the client to sign off on the design, which the client then does. Fine. What then happens if the wall of the house, which faces the weather, the prevailing wind, promptly leaks because the materials are not adequate to exclude the Scottish weather? The client does not plan to get a house which leaks plus a right to sue somebody. He wanted a house that didn't leak. And arguably the responsibility to provide that rested with the designer, even if the design was signed off. But the problem with that analogy, and any other I could give my Lord, is that my Lord will say, yes, that's very well, but let's look at what the provisions in the contract say about how the design process was to operate. And we have that in our submissions. So I don't take that any further. Which leads me to the submissions by Curry and Brown. Now, I should be able to move through these reasonably quickly. One of the topics dealt with is whether the definition of the areas to which what I'll call the ventilation derogation, the provision to depart from the 6 air changes an hour in guidance, whether that area was clearly defined. We submit no. My Lord should therefore be aware that in paragraph 7.1 of the submissions by Curry and Brown, they say that it was clear to what parts of the hospital that change should be applied. It's just a difference of view which we don't accept.
Well, Curry and Brown don't seem to recognise it as being a difference of view. It is common ground. And a matter of record that the ventilation derogation did not apply to isolation rooms or specialist wards.
Yes.
So there is a difference of view.
There is a difference of view. The difference simply, Lord, is that we accept that by carrying out an exercise of looking at a number of different locations, it's possible to come to a view as to where the derogation should be applied. But we have suggested in our submissions that really that should have been made simple and patent somewhere, rather than requiring that exercise to take place. And of course, as Curry and Brown go on to point out, the challenge is that the derogation was then in fact applied in areas which on their definition it should not have been applied to. Well, there's some discussion from time to time here and elsewhere on the status of SHTM 0301.
Just on the, only if you have the reference, the Councils of Inquiry's position on that point is made in which paragraphs?
I don't have a note
Very well.
of
I
that
can
paragraph,
find
but my lord, there's a section of the submission in which we deal with possible interpretations. We look at the different interpretations and then we indicate what we think on balance is the correct one. And we suggest it would have been far easier if somebody had said, well, let's just get it clear. Where are we applying this? Where are we not applying it? And written that down. Well, again, just to illustrate a point that's going to crop up in these documents repeatedly, in paragraph 16.2 of Curry and Brown submissions, they say SHTM 0301 is non-mandatory guidance. Now, Lord, I don't want to get into the debate about whether it should be treated as effectively mandatory and so on, which has been had elsewhere and also by a number of the witnesses. But of course, the point was that it was intended, at least prior to the contract signature, to be a compulsory document to follow. And in fact, it still appeared in a list of documents of compulsory guidance, subject, of course, to what had been agreed. I'm simply illustrating that that debate is still live. Now, the approach that is adopted by Curry and Brown leads them to the conclusion that the whole issue of the ventilation derogation is a red herring. And that's set out at paragraph 37. We do not agree. And we remind the Lord that the ZBP strategy paper, which accompanied it, was not, shall we say, viewed favourably by any of the witnesses of expertise who subsequently looked at it, whether instructed by this inquiry or by NHS GGC. And we still don't really know why it appeared at the very last minute.
All right, just reflecting on paragraph 37. Now, I take it that is proceeding on the basis that the ventilation derogation had no application to specialist ventilation areas.
That must be the case. But essentially, my lord, the Curry and Brown position is it was only guidance. There was nothing wrong from departing from it in the circumstances of the case. It's only, the air change rate is only for comfort, and there's no evidence that it's actually caused damage to patients. And these are set out in some detail in the preceding paragraphs.
But at risk of repeating the question, the premise is that the derogation only related to general wards.
Yes.
Right.
which of course brings up different questions as to what, were they all general wards or not? But anyway, that is the premise, indeed. In paragraph 50, Curry and Brown take issue with our description or our criticism of Mr. Pardee for saying that the air change provision was unnecessary. Now, I don't have the paragraph reference, but it was put to Mr. Pardee that that was perhaps an unfortunate phrase to apply to a long-standing UK requirement for 6 air changes an hour in general rooms. So was to dismiss it as unnecessary, and I thought he accepted that that was perhaps an unfortunate use of the word. But that was all that we were seeking to make with that point. Well, the other issue that emerges in these submissions is, of course, the role of Curry and Brown, not only at the time when the contract discussions were taking place shortly before the contract was signed, but also more generally. And there was a debate, my Lord will perhaps recall, as to whether Curry and Brown should have done a bit more than they actually did. And I illustrate that by looking at paragraph 63, where the writer says, Curry and Brown was entitled to assume, leave the bit in brackets, that Mr. Seaboard and Mr. Moore complied with their own internal reporting obligations, which were out with their knowledge. Now, I make 2 points about that. First of all, it's been broadly accepted that making assumptions is a very risky thing to do in a construction project. And secondly, I say this, if you're assisting with project management, particularly in the context of a part of the process which is under pressure of time, is it really unreasonable to suggest that you should check, not that you should do these things, but you should check they've been done as part of the job that you're doing?
Apologize if you've already told me this. The reference to entitled to assume is addressing what criticism of Curry and Brown?
Well, it's referring to, at that point, the question of who should have told someone further up the tree than Mr. Seaborn about the derogation. And
Right, simply the passing of the information.
And the point I'm simply making, and it's probably best actually illustrated by a later paragraph. It's paragraph 65 and 66. My Lord will recall that there was at one point a statement in these contractual exchanges suggesting that IPC sign-off was to be obtained. Now, just take that as a premise for the moment. There is no suggestion from where I sit that it was then the job of Mr. Hall or anyone in Curry and Brown to go away, find an IPC specialist, engage in exchanges and obtain that information, because he wouldn't necessarily know where to go. I agree to that extent. But if you're under this pressure of time and someone has said IPC sign-off is required, is it not part of the project manager's job to say, Alan, remember you were to get IPC sign, you got that? Can I tick that box? Has it been done? Have you got it in writing? But whatever the point is. So this is where there's a debate, I think, as to whether the Curry and Brown approach of saying anything to do with anyone else in GDC is nothing to do with us. We just stay well clear of that. We're only looking at the actual project itself.
We're looking at we're looking at a few days in December of 2009.
Correct. Yes.
At that time, Curry and Brown are providing the fuller service.
Yes. Although they continue to provide project management services after that date. What they don't do is provide the list of subconsultants. I have to say, if one looks at paragraph 65 of the submissions, where it was suggested, I think, on our part that Curry and Brown were perhaps downplaying their role. And they're saying, no, they're not downplaying it, they're merely explaining it. And then it says, the relevant questions and oral evidence proceeded on the incorrect premise that Curry and Brown had some kind of technical input into advising on the decision. Well, I'm not sure that they did, but my point is simply, if you're assisting with project management, in order to be of assistance, is it really unreasonable to suggest if something was supposed to be done that you check with your people you're working with? We make no point beyond that.
Well, it might not be unreasonable to expect people to behave in a particular way, but in the context of a commercial project subject to contract, is Curry and Brown not entitled to say, well, we were obliged to do what we were obliged to do, but that obligation did not go the distance of essentially supervising Mr. Seaborn.
If one takes on a role which contains a general statement such as project management, I'm not sure one is entitled to be as hard-nosed as that. Supervising Mr. Seaborn would be the wrong phrase.
Okay.
But if you're assisting in the process of getting this to conclusion, which they seem to have been in some way, then is it really reasonable to say, well, yes, we saw this reference to IPC, but we just ignored that completely. We left that to somebody else. We didn't even ask. And in my submission, that is pushing their envelope in the wrong direction. Maud, I have a few more points just to make. Maud will have seen in the submissions for council to inquiry that we made the suggestion that the ventilation derogation should have been highlighted in some way. That's a matter for my lord.
Well, am I competent to, I mean, is it enough for me to think, well, it would have been a good idea if it had been highlighted in some other way? I mean, it's not the, I mean, I think it's probably in the DUV Sud submission expressed with some energy that the documentation of the air change rate was in precisely the place that someone who knew about contracts would expect it to be.
Yeah, and we make a different submission.
Well, are we entitled as, I mean, do we really have the decision-making tools to say, well, it would have been a good idea if, in the context of, I mean, I suppose there is the qualification. This is a contract subject to an obligation to cooperate, whatever that may mean. But should I not be a little bit careful about second-guessing people who should be assumed to know what they were doing. And I appreciate the assumption isn't perhaps an equal assumption, but
Well, I accept, my lord, that this is an issue on which views differ, bearing in mind that, and I think the point that I was going to make was that our position, our submission to you, is that this derogation was quite different in scale and effect from the large number, paragraph 67.1, hundreds of items, clarifications, responses to queries, and so on, that were in that log. If that is right, and if on the face of the contract that parties were about to sign, the guidance is still specified as compulsory, it's not subject only to what's written somewhere else. It may be that those who were most closely involved at the time say, well, what's the problem? It was in the log. It's in with hundreds of other things, but you'd find it somewhere if you knew where to look. But for a change of that kind, and we've seen the consequence, of course, that it was never, for instance, drawn to Scottish ministers' attention, it is our submission that that was not an adequate recording of something of that significance.
well, you say it was not drawn to Scottish ministers' attention. It wasn't really drawn to anybody's attention.
No. And that's the challenge, because a minor query.
I apologise. That has to be qualified by looking perhaps a little bit more carefully at what Mr. Seaborn said happened.
Yes.
But I don't think we identified anyone else who admitted to having become aware of it at or about the time.
No. I'm not sure. I think the evidence, my lord, was that nobody apparently knew about it as a matter of fact, other than possibly Mr. Calderwood very late on, who said he may have had it mentioned to him, but it didn't really dawn as significant. But the answer may depend, my lord. The thrust of the Curry and Brown position is this was a perfectly good suggestion, had no real effect. It's not a big deal. You can leave it with 100 of other things in the log somewhere. That's fine. The people who are working on it know where to find it. The alternative view is this was a significant decision with significant ramifications for any number of hundreds of rooms, departure from apparently intended to be compulsory guidance, and so on and so forth, and a quite different type of change to the hundreds of other queries in that log. And the fact that there were hundreds of other things in the log, in a sense, makes the point.
I mean, not very relevant to what you're saying at the moment, but you've just characterized the Curry and Brown position. But would I be right in thinking that when Mr. Calderwood did learn about it, and if I'm wrong about this, please tell me, and when he understood that it had to do with the maximum temperature variant, he thought it was quite a good idea.
Yeah, well, almost the next point.
By that time, decisions had been made,
yeah.
Buildings had been built,
Yes.
but
Well, that may be. I have to say, my lord,
I may be wrong in my recollection.
no, it was something along those lines. Both Curry and Brown, from their perspective, and TUV Sud from theirs, make something of things said by Mr. Calderwood.
Mm-hmm.
And I, for my part, wearing my hat, question whether selecting Mr. Calderwood as the best historian on matters of technical detail is really very helpful. And one perhaps picks this up on the next point. In paragraph 74, Cowie and Brown say that in our submissions, we state that Mr. Calderwood's oral evidence was that he worked on the basis that the technical advisors would have approved the ventilation derogation. And then they criticise the use of the phrase approved, because they say, well, it wasn't for the advisors to approve anything. It was for their board to approve it. And all I say is, if you're listening to a layman and there's only one team of experts on the plot, and that was Wallace Whittle, is it really a fair criticism to say, well, I'm assuming the experts approved this? I would suggest not.
Right. It's really just a point about use of language.
Yes. But I suspect Mr. Calderwood was not at the time engaging in a careful analysis of the contractual structures in place and the communication routes that were in place. Well, if I move on, if I may, to 75.4, that paragraph deals with the issue which arose in the oral evidence of Mr. Hall, where he suggested that the agreement of the ventilation derogation was in some way provisional and could have been changed later. Now, that was all we have said in our submissions is this, that there is no suggestion of consideration of this agreement as provisional anywhere in any of the documentation at the time or in any of the witness statements from anyone. But all we are saying is probably made less important because, as we understand Mr. Seaborn's evidence, he said no one thought about that. That wasn't an issue that was discussed or debated. We weren't thinking about that. If we weren't thinking about it, it may or may not be a correct analysis of the way things might have happened, but no one was thinking about it as something provisional to fix later. And we say no more than that.
Sorry, so my fault. Counsel to the inquiries, certainly, when Mr. Seaborn gave his evidence, he threw into the mix that the ventilation derogation, which it agreed to pre-contract, could have been revisited. Although I think it was accepted that that might give rise to a compensation event.
I think that may have been Mr. Hall's evidence, and then Mr.
Right.
Seaborn touched on it as well.
Now, the point that counsel to the inquiry make is, well, no doubt you can vary a construction contract at cost or at saving, I suppose. But what counsel to the inquirers are saying, which is being responded to, is that, well, there was no evidence that anyone applied their mind subsequent to, even either in December 2009 or subsequent to that, to such a change.
Correct.
Yeah.
That is all we're saying. So it's interesting, but it doesn't take us very far. If we come back to the question of the application of the ventilation derogation, in paragraph 79, Curry and Byrne criticised counsel of the inquiry for dismissing the question of which rooms it applied to as a large academic issue. And they say the real question is how the solution came to be applied much more widely than intended and agreed. Now, we do accept that the question of how it came to be applied more widely is something we deal with. And the only difference between us and Curry and Brown, I suggest, is that we say that the lack of precision on its application in writing at the time may have played a part in how it came to be applied more widely.
But I suppose you'd have to accept that there's an element of speculation there.
Yes. On paragraph 90, it sets out one of the paragraphs dealing with the changing role of Curry and Brown and says, well, Curry and Brown ceased to be a technical advisor, ceased to have a technical team to call upon. Any reference to them having a technical team after that time was incorrect. We agree. It's still a bit mysterious why so many people thought there was still a technical team, but we don't really know. It does suggest some failure to communicate the change. And I suspect there is broad consensus that the job of communicating that change should have been in the hands of the person who instructed the change, in effect, the project team.
I think I got a feeling of the very presence of Mr. Hall sort of seemed to have a reassuring quality.
Well, that's quite possible, my lord. The difficulty is that there's a little bit of wrangling in these submissions over, well, remember the context. And when you come to TUV Sud, they say, oh, we only advised Curry and Brown. We didn't advise anybody else. Well, leave aside whether that's accurate. But we know the structure. Curry and Brown I've been criticized for calling it lead consultants, but they were the consultants at the top of the pyramid of sub-consultants who worked to them. And clearly, Mr. Hall may have been the route for communications, but maybe he engendered confidence. I don't know. Just to pick up, my lord, I started by mentioning the different views on the employer's requirements and so on. Paragraph 101 is the nearest I can get to a summary of the Curry and Brown position. The employer's requirements were by their nature not intended to be fully prescriptive and detailed design specifications. It was for the design and build contractor Multiplex to develop the detailed design after the award in order to meet GGC's requirements. That's broadly the position that Curry and Brown say. It's for the designer to use their expertise. The only other things I want to say in passing, Maud, if one looks at paragraph 107, there's a quotation, I think, from our submissions at the top of page 36, just before the start of 108. While Curry and Brown were clearly an important part of the process and might have been the communication of a vehicle for escalation, if so instructed, the ultimate responsibility for escalation of changes to the employer's requirements must lie with the project team and Mr. Seaborn. One might have thought that was unexceptionable, but Curry and Brown challenged that. And one sees that at 108.4. Curry and Brown disagrees with the conclusion that it was clearly an important part of the process. And might have been...
Sorry, just so that I'm following.
Yeah. The part of our submissions criticised is at the top of page 36.
Yes, and the word escalation in that context is informal escalation, advising
of the change that was being made on ventilation.
Right. And I mean, you don't seem to implicate Curry and Brown in any respect.
Well, all we've done is describe them as an important part of the process, where they were clearly one of the few people who were participating in these discussions. I don't think that's an exceptional phrase. And then I say, well, if they'd been instructed to escalate, they might have been capable of doing that.
Is this,
That's
is this really revisiting the point that we looked at some time ago about paragraph 60 or so about Curry and Brown saying, well, it wasn't our job to do Mr. Seaborn's job.
Yeah. Okay. And the only other point that I want to make before I leave Curry and Brown is that the one thing one doesn't really find in these submissions is a discussion of the signing off of apparently significant numbers of drawings and so forth by Mr. Hall on an unqualified basis, by which I mean without saying, please note I'm signing this only in relation to clinical functionality or whatever.
Right, so your point there is that we find Mr. Hall's signature on drawings from time to time. Now, in contractual terms, the signature could have only any meaning if he had been delegated, possibly informally, the authority to do that by Mr. Seaborn.
Mr. Seaborn or Mr. Moore, yes.
Or Mr. Moore.
Yes.
And maybe later on Mr. Loudon. Right, having said that we find the signature, what then?
This was a matter of some controversy as the evidence developed. The contract provides for drawings to go to the project manager to approve them, and for the contractor not to build until they've been approved, and for a process of signing.
That's a reference to clause 21 of the NEC 3.
Correct. And then there are detailed provisions elsewhere for the different types of topic that are to be covered in the approval process. The point that I make is that Mr. Hall says that he told everybody, and I'm paraphrasing, that the only thing they were signing off was clinical functionality. But as the Lord will probably have picked up, there's at least some controversy as to the fact that his signature appeared on items. Now, he will say, not a problem, because I made it clear I was only ever signing with that in mind or on that topic, but he just signs them. And of course, if he signs them, they have a contractual effect. If he signs them A, B, or C, as we've discussed. If he signs them A, it means get on and build it. It's just simply that's not discussed, really.
Yes. And as you point out to me, there may be a question as to what clinical functionality extends to.
There is a separate debate about clinical functionality, which is dealt with at some length in counsel to inquiry submissions. Is it as hermetically sealed as Mr. Hall might have suggested? Does it apply to various things, which in interest of time, I'm not going to go to. Lord, that would allow me to move to TUV Sud, who are representative of the other end of the spectrum. They've put in a long submission. In parts, they agree with things said by counsel to inquiry. In parts, they deal with issues that nobody challenged. Were Wallace Whittle involved in validation, to take an extreme example? No, no one suggested they were. So I don't need to go to any of these parts. And the only general comment I make is that my submission on the correct import of the totality of the evidence of Mr. Pardee of ZBP is that he made a number of concessions in his capacity as a specialist ventilation designer of things that he could or should not have done. And I'm not sure this submission actually reflects what Mr. Pardee appeared to concede. Now, that's my interpretation of his evidence. I'll give my Lord one or two references to where they appear, but obviously the conclusion on the correct interpretation of his evidence is a matter for my Lord. So if I can pick up a few points quickly, in paragraph 7 of the TUV Sud submission, there's a narrative of what is said to be Mr. Seaborne's evidence, where it said he was relaxed about the technical advisory team being stood down. According to Mr. Seaborne, he and his team were more than capable of assessing designs and design information. Well, the debate as to whether that was an overly optimistic view, but he did give evidence broadly to that effect. But the only issue I take is that it then goes on to say in this paragraph, and that would of course include stipulating what NHS GGC was asking for in terms of specification and requirements. And I question whether Mr. Seaborne's evidence goes to the extent of accepting that he could have stipulated and specified what was required, for instance, for a specialist ward. That's perhaps taking it a little far, a bit of a non sequitur. Well, there's a general point made in paragraph 22, and the fault may be mine. I'm not sure exactly what this is referring to. It's a long sentence, submitting that when it comes to considering the adequacy or otherwise of a particular feature of the buildings, a relevant feature should be assessed against the outcome which was requested or could reasonably be taken to be required to achieve, rather than against the expectations or opinions of individuals who are not involved in the design construction process at the time and often spoke without proper knowledge of the process and frequently in hindsight. That I simply make the general point. I'm not quite sure who is being targeted by this criticism, or that I can recall any particular challenge being made to anyone on the basis that they weren't entitled to comment on the design of the buildings.
Well, at this stage in the closing statement, the author is offering me assistance in how I should approach evidence and submissions, which is always welcome. But they are general points.
They are general points. I'm not sure who they refer to, and I'm not sure it's later specified. There is a point made in paragraph 34, page 8. The draft HTML 301 document from 2009 was just at a draft. It was not a finalised document. At the time of design, no one knew what the finalised version might provide.
What is the relevance of that observation?
That's precisely my question, my Lord. It was a contract document.
Yep.
And I don't believe there's been anyone else who has suggested in evidence that there was some kind of doubt over what was going to be provided and that had any relevance to any of the issues that we...
I mean, it was a draft.
Yeah.
The contract recognised it was a draft, but said, nevertheless, follow it.
Yep.
Or at least on one interpretation of the contract.
Indeed. Now, I needn't reiterate the point about the approach various parties have taken to the value of the ZBP strategy paper. Obviously, there's a difference of view on that. If I could go then to 61. I think this may go a little far, 61 says, there is no doubt that NHS GGC agreed to the proposal that a rate of 2.5 ACH would be delivered, and that no more than 5 people could be accommodated in a room from a ventilation perspective. Now, I accept that there are accurate quotations from some of the documents, but what I suggest to my lord is that while there was clearly discussion about where the figures came from, which seem to have landed on a maximum of 5 people in the room, I'm not sure that it's obvious from any of the material this inquiry had that a specific constraint on the ability to accommodate people in the room was ever really focused upon in any of the materials.
The reference to 5 people is taking you to, is it 40 litres
Yes,
per
second.
second?
Yeah, yes. My lord, perhaps remember that there was some evidence that someone had got onto IPC and somebody had put a finger in the air and said, how about let's use 5, and there was some debate about that, was then fed back into the process. But I think my point is simply that there is an issue over whether room occupancy should be formally restricted, but it didn't seem to me, with respect from the evidence, that anyone was really at the time thinking about this in the context of constraints on room occupancy.
Certainly, we haven't heard any evidence to indicate that since 2015 that constraint has been applied.
Yep. Now, in 67, criticism is made over the use of the phrase Mr. McKechnie advised NHS GGC to accept the proposal because it said, well, he mentions the guidance. It's a matter for my lord. I suggest that the suggestion that Mr. McKechnie advised is a perfectly reasonable point. In paragraph 69, it said Mr. McKechnie had no direct contact with NHS GGC. Now, from what little we know, I'm not sure that's quite right. And in any event, it said, well, his contact was with Curry and Brown. But unless it's being suggested that if there was an exchange or a meeting and Curry and Brown and Mr. McKechnie were in a room, Mr. McKechnie would turn to the representative from Curry and Brown and say, well, I'm not speaking to him over there, I'm only speaking to you. I'll tell you what I think. And then Curry and Brown would say, Mr. McKechnie thinks. It's to adopt, in my submission, a somewhat technical approach to an accepted contractual structure. Mr. McKechnie, Wallace Whittle and their representative, Mr. McKechnie, were the only experts on the plot, if I can use that phrase, at the time. And it's not suggested that Curry and Brown had of themselves the expertise to deal with these issues. So if anybody was commenting on them, it would be him. Well, I've only a few more points on Curry and Brown.
TUV Sud.
Sorry, TUV Sud. Sorry, I didn't notice. Yes, my lord is right. TUV Sud in 86. There's a criticism of statement that CBUs, these units that were deployed, cannot operate at more than at 6 air changes an hour. The only point that Council of Inquiry was seeking to make is as soon as you decide to adopt these units, you in effect have to accept the proposition that they're not going to be able to provide air change rates compliant with guidance. This point is no more elaborate than that. Well, and more significantly, if we go to 109, the suggestion is made in terms that Ward 2A was identified in the clinical output specification as a general ward. Now, this is a matter entirely for my lord, but my lord will recollect, I'm not going to dig it out for the moment, but the clinical output specification for Ward 2A, which for my lord's notes is bundle 16 at page 1599, is a document headed.
Just give me a moment. Bundle 16 document.
Document 16, bundle 16, document 16, page 1599. My lord will remember it. It's a document headed Hemato-Oncology, talking about the National Bone Marrow Transplant Service. It doesn't contain much technical detail, but that's what it's talking about. And therefore, in my submission, the characterization of the clinical output specification as labeling this a general ward is, in my submission, not a fair one at all. And I thought that that matter had been accepted by both Mr. Pardee and indeed Multiplex. And the reference to that is in our submissions at paragraph 699. And the reason why it's important is that if one goes onto the next page of the submissions at paragraph 121, the statement is made, it was for NHS GGC to assess from a clinical perspective whether this agreed feature, which is air pressure, would be appropriate for the different use to which Ward 2A was eventually put. That mod is to suggest a process rather different to anything the inquiry has heard of in evidence. Because as I understand it, whatever debate there is about the clinical output specification, 2A was always intended to be the National Paediatric Bone Marrow Transplant Unit. So the suggestion that somehow it was designed as it was intended to be a general ward and then put to some other different use doesn't seem to be borne out by the evidence in the inquiry. And that obviously permeates these criticisms. But if I may just take a few minutes just to finish on TUV Sud, my lord, the 139 discusses isolation rooms. It doesn't, in my respectful submission, pick up Mr. Pardee's acceptance that he ought to have looked at the constraints on the use of PPVL rooms for immunocompromised and infectious patients, nor does it touch on the placing of extracts in these rooms contrary to guidance. And the approach taken by TUV Sud to my lord is probably quite well illustrated in, if I can go to paragraph 227, where there's a note that the original clinical output specification for Ward 4B makes no reference to air change rates. Now, if Maud can just take it from me for the moment, and that is correct. It makes lots of technical references to immunocompromised patients and so forth. The TUV Sud position is that since it didn't specify air change rates of 10 air changes need not be provided. Now, the question then is, what role is a specialist ventilation designer providing? If all you have to do is read what the board gives you. The other point that emerges slightly earlier, Maud, is a proposition. Maud will remember the debate about Ward 4B, the changes to Ward 4B, and how things came to be as they did. TUV should advance what I suggested, a new theory. And that theory emerges in paragraph 211. And their theory, if I can paraphrase it, is this.
Sorry,
211.
211.
Yes. The way I paraphrase it is this. The original intention was to have a hemato-oncology ward. Then along came the idea of adding a bone marrow transplant unit. And TUV should say in terms, once you have the new intention, the correct interpretation of the materials is that you completely ignore everything that has gone before. You have a clean sheet of paper. Nothing that had previously been discussed is relevant. Now, my lord, our position is that we find that difficult to square with the way things were done, but that is their position. And the only other thing I need to add is to give my lord the reference to the statement of their approach to the role of the specialist ventilation designer, which you will find in paragraph 337.
This is 337 of the TUV Sud
TUV submission.
statement.
Yes. And Maud will see if you ignore the first sentence, clinical output specifications for departments or other areas having a clinical function should set out in detail and in the clearest terms possible the relevant patient cohorts and activities, together with a schedule of accommodation and so on. In addition, the Health Board's brief should include documentation identifying the environmental parameters of all spaces within such areas, including precise specification of applicable ventilation parameters such as air change rates, pressure differentials, levels of filtration, and temperature. So the TUV Sud position, which I've illustrated by their references elsewhere, is essentially this, that the board has to specify every last detail, and if it doesn't specify it, it doesn't get to complain if it doesn't get it. My question is, what is the point of having a specialist ventilation designer? If all they have to do is read off the list and build it, you might as well go straight to build. Because there's no application of skill, there's no discussion of guidance, nothing. It's all to be specified by the board. And that, I think, given the time, I'm sorry, it is taking rather longer than I had anticipated, but that is all I wanted to say about TUV Sud.
Now, you're not finished, I gather.
No more. These are the biggest parts of what I have to say.
You may not be able to answer this, but what would your estimate be for time remaining?
3/4 of an hour, perhaps.
Right.
In some of the case of the other submissions, I'm relatively brief, a little longer on one or two others.
Right. Well, that obviously has consequences for other CPs, but my impression is that over the week we have enough. We have enough time. Well, it's a little after 1:10. We will sit again at 2:15. I anticipate there may be film cameras, so people may wish to be aware of that.
I stand.